Hello, ladies and gentlemen. This is Attorney Sharp Raleigh for breaking news and something unexpected, which I thought was completely dead, came out revival from the Obama administration. It's kind of a good news for H-1B visa holders, EB1, EB2, EB3. It's a 600 pages of advanced copy of the rule for the retention of EB1, EB2, EB3 immigrant workers and program if improvements affecting high-skilled non-immigrant workers. Final rule. Okay, just before I start talking about this, and I have it on my website here, and I'm going to click on read more, which will open to the PDF file. I wanted to let you know that this is another one of the rule making process. That means basically almost like an executive action, although it goes to the rule making. um, this is not something that you can rely on for long because we don't know how those kind of rules will be interpreted by the Trump administration. So while it might be good for as soon as it becomes effective, and this is another question we're having, it is going to be published tomorrow, but it probably will not be effective for the next maybe 30 or 60 days. So the question is, when Trump takes power, will he reverse that immediately or will have to go through the process to reverse it? I don't know the answer yet. So I'm just going to still go over the rule because it has some good stuff, although it has been changed from the original one we talked about. And basically, what it says here, and the final rule here addresses after they publish it, etc. And this is the summary. The you have the AC-21 issues, you have the H-1B grace period, you name it, some very interesting things, and even an EAD for I-140s in certain situation. And I am going to try my best to dissect that. It's a 600 pages, but I'm not going to go over all of them because it's going to be taking a lot of time. So what it does here is, for example, there will be clarification of the situation under AC-21. Number one is AC-21 extension of stay under AC-21 for those who are being sponsored for LPR and their dependents on H4 stay beyond the 6 year limit pursuant to the AC-21. Then you have the INA 204J portability. The final rule addresses the ability of certain workers who have pending applications for adjustment of status to change their employers or jobs without endangering approved form I-140 on their behalf. Then you have the H-1B portability. It goes on like that, and we have the link down there where you can read a little bit about that. So now bottom line is, what is interesting in that is they have, for one, of what they propose here and what they have been accepted, seems like the 180 days rule when it comes to I-140. As you know, the I-140 is the umbilical cord whenever you pass 6 years. And what this rule is saying right now is that the employer will not be able to just revoke it because employer wants it to be revoked as long as you pass 180 days from the date the I-140 has been filed, which is something which was not there, and I always said it was not there, but now it might be there soon. And again, the question with it, will the Trump administration continue accepting this rule? It's kind of late in the game, but hey, it's there, so we'll talk about it. Now, then also eligibility of EAD. One thing they have changed, they're not going to give I-140 EAD to everybody. They're going to give it only to certain situations where they have some kind of compelling circumstances. For example, you pass 6 years and you are reaching a situation where you need the EAD, they will consider it. And again, we don't know how this is going to unfold once the government changes. Then you have the 10-day grace period to allow people to basically on E2, E1 to, even if you're out of status, you will be able to shift the status. And then they have the 60 days grace period, the one that everybody was waiting on. As you know, once you're on H1B, you're shifting the day the H1B stops, the day you went out of status. But now with this new rule, hopefully the 60-day will come in. I'm not going to go over all of them because there's so many of them. I will try to dissect it. I just made this video really quickly because this is appearing on the Federal Register as from tomorrow as final rule. Let's see if it will, when it will be effective, and that's where the guessing game is coming. Plus, also, will Trump keep it? That's another big question. But I'm hoping if it stays, it will be some kind of relief to many people. Although we know it's kind of late in the game, we hope things are going to get better. And the best thing that Obama can do actually is make all the dates become current, and that will help a lot of people. But having said that, I just wanted to bring this video to you in order to kind of quickly tell you things are changing a little bit, and there are many things in there. You can read this. It goes on and on and on, and it might be to your advantage to have it or not, but ultimately this is under rulemaking, almost executive to executive power, so there is a chance it will be reversed. So although it cites a lot of law which are existent, I am hoping it won't be reversed, but it might be. So be ready for that. And anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Good luck to you, and subscribe to our video for any updates. And you will have the link below. You can read the whole 600 pages, and I'm trying to dissect it for your best. So good luck to you. Wish you all the best. Thank you so much. Bye bye.